everyone, I am attorney Vince Hein, and in this video we're going to talk about marital property agreements. Now, I'm an estate planner and elder law attorney, so when I do marital property agreements, we're generally not talking about prenups or postnups like your family law attorneys do. We're really talking about marital property agreements for the purposes of estate planning. And the general value of marital property agreements is twofold. One is that you can use a marital property agreement to avoid probate. So a marital property agreement is also known as a Washington will, because the state of Washington, also a marital property state, they essentially came up with it first. Wisconsin borrowed from it, and ours is actually a little bit better from what I can tell, because I believe in Washington, and I'm not licensed there, but I believe in Washington you can leave it to your spouse or to your kids, but you can't leave it to a trust and do a lot of the other things we can do here in Wisconsin. But the short story is a number of planners use marital property agreements. Sometimes they do it instead of using a will, because a will only governs probate assets, and once you have that marital property agreement, you're not going to have probate assets, essentially. And so, in addition to avoiding probate, the other value of using a marital property agreement, at least in the general estate planning sense, is you can also get a double step up in basis at the death of the first spouse. So other states, you would only get a single step up in basis, or a 50% step up, if you want to say it that way. In Wisconsin, there's a presumption that you have opted into the marital property laws, but technically that presumption could be rebutted. So once you have a marital property agreement in place, well, it's going to be difficult, if not impossible, to rebut that presumption. So what that means is, if you have capital gains assets at the death of the first spouse, the surviving spouse can sell off those assets tax-free, which is a huge advantage that Wisconsin offers, which is nice because marital property generally can be kind of a pain, because it really means, the way I think of it is, the person whose name is on the title does not necessarily reflect true ownership. So at any rate, the marital property agreement, when we do an opt-in, right, we can avoid probate, and we can guarantee the double step up in tax basis at the death of the first spouse. Now, perhaps not surprisingly, a marital property agreement is for married couples, so if you're single, you can't do it. That said, sometimes we do marital property agreements in other contexts. So in the Medicaid planning context, when we have a married couple and we have one spouse who's on Medicaid, we often always do a opt-out marital property agreement, where we're not concerned about the step up in basis anymore. We're concerned with the Medicaid rules, and we just want to make clear who owns what, right? What is the community property? What is the community spouse's assets, and what is the institutionalized spouse's assets? We also want to, and this is very important because of a case in Wisconsin, we also want to say that at the death of the first spouse, the surviving spouse waives their right to make a spousal election and to any of their rights as a spouse, right? If you don't, then technically you could have what's called a divestment by death issue in Wisconsin. So there's other uses for marital property agreements, but generally it's either for Medicaid, we're saying we're opting out, right? Or for a lot of estate plans, we're saying we're opting in, and we want to avoid probate, and we want to make sure the surviving spouse can sell off assets tax-free. So these things can get pretty complicated pretty quickly, but if you do have questions, feel free to reach out. But think of the marital property agreements that I do in my office as really estate planning tools and also Medicaid planning tools. And they're going to be different from what a family law attorney would do when in the context of a prenup or a postnup. Those are perfectly valid marital property agreements as well, but not the kind that I do in my office. Thank you so much for watching. I'm attorney Vince Hein, and hope you found this informative.